If 26 years ago, a party had wrongfully told the surrogate's court he was the only heir to an estate, can that party now benefit by gaining full title to the property by adverse possession? To find out, you have to read Golub versus Mielnicki, but it's 38 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, where I cover New York Court of Appeals cases, and I try to do it in 5 minutes or less. This is the episode on the case of Golub versus Mielnicki. The index number for this case is 2025 New York Slip Opinion 01670, published by the New York Court of Appeals on March 20th of 2025. The issue in this case is when a person inherits erroneously property and holds it for a long period of time, can that person obtain the complete title of the property by adverse possession? To understand and appreciate the context of this case is a little bit of background law that's helpful to understand. There's 3 different claims here that have to be understood. First is fraud. Fraud has 5 elements. The elements are a misrepresentation or a material omission of fact, which is either untrue or known to be untrue or recklessly made for the purpose of inducing the other party to rely upon it, justifiable reliance of the other party on the misrepresentation, and injury. If you don't have all 5 of those elements, you don't have fraud. The next claim to understand is there's a claim called breach of fiduciary duty. The elements of that claim are the existence of a fiduciary relationship, misconduct by the defendant, and damages directly caused by the defendant's misconduct. Okay? And the last thing you have to know is that there's a concept called adverse possession. And adverse possession is a method by which a party that does not necessarily have control of real property can gain control of real property, can gain actual title of the real property if the person possesses it in certain ways. To establish a claim of adverse possession, the occupation of the property has to be hostile and under a claim of right, actual, open and notorious, exclusive, and continuous for the period of time. Usually it's 10 years. If you have all those elements, then you can gain title, gain clean title to a property by adverse possession. And the point of adverse possession is we don't want property to be up in the air as to who owns it for a long period of time. It makes property unusable, unsellable. We want the law wants property to have clear owners. All right. So what do we have? The facts in this case are there was a person named Dorothy Golub who died without a will, what we call intestate, in 1992 at age of 85. She originally had 2 brothers. One of those brothers had a son. The older brother she had sort of become incommunicado. No one knew what happened to him. So the nephew of of Dorothy Golub, 2 weeks after she died, went to the surrogate's court and said, I want to be the administrator of my aunt's estate. The only person I know is still alive is my father. The other brother we think he's dead. We don't know where he is. And he submits to the surrogate's court, an affidavit from a lawyer who says, I know the family and I believe that the other brother has been dead since 1985 for several years. The surrogate's court gives the nephew letters of administration, says you can be the administrator of this estate. Ultimately, the property she had included a 3-story building in Manhattan, which is worth a lot of money. It goes to the brother, who then disclaims it, which means it gets inherited immediately by the nephew, who's the administrator. And he then nurtures and watches and renovates and works on this 3-story mixed-use building for 26 years. He renovates it, he mortgages it, he leases it out to tenants, he does all the necessary work. And eventually in 2018, he tries to sell it. And when he tries to sell it and they do a title search, they realize, the title company realizes, oh my gosh, that brother that everyone said was dead was actually alive when Dorothy died. And if that's true, then instead of 100% of the property and 100% of the estate going to the nephew, 50% goes to the nephew, and the other 50% goes to that other brother's line, per stirpes, which means by the line, right? So instead of the nephew having 100%, he should have 50%. To his credit, he reaches out to the other family members and says, hey, just a heads up, I just found out that your brother, the brother was alive. And then he files an action to have the property put it fully in his name, the nephew, by an operation of adverse possession, basically saying, I've had it for 26 years. I've been working on it under the illusion, even if I was wrong, that it was my property completely, and I should now have it completely clean title. Ultimately, the other party says, no. We are entitled to some. We're entitled to some of this. Ultimately, the Supreme Court grants the motion for summary judgment, basically saying, give it to the nephew. The nephew gets it, even though he was the party that was wrong in the beginning by claiming that the brother was dead, and is now gaining by his own wrongdoing to say it's now fully my property. It gets appealed to the appellate division. They affirm what happens. It goes to the Court of Appeals, and here the Court of Appeals has a majority decision and a dissent. The majority says this is his, okay? Because the letters of administration were proper. They were accepted by the surrogates court. They gave him the power to be the administrator. They believed that the finder of fact there believed that he was the sole heir, the sole line that was existing at the time of Dorothy's death. And he satisfies adverse possession. He was open, notorious, hostile. It doesn't matter the fact that the other family didn't even know that this property was passed down to him. That's not relevant according to the majority. The important part here is we want clean title. We want to be able to allow there to be finality and certainty as to who owns the property. I will say there's a very strongly worded dissent by Judge Rivera, who does not like this at all. She says that this is a real problem. She would not grant adverse possession for the same reason that I just mentioned. The wrong party, or the party that was wrong, that didn't do the due diligence allegedly on the front end to find out whether the uncle was alive or not, that party is now benefiting by his own lack of due diligence. He's benefiting by his own wrong conduct. So Judge Rivera would say, as a matter of justice, we should not grant this adverse possession. It's impossible to have adverse possession against someone who doesn't even know they own the property. But the majority here is that adverse possession is proper, and that the original application was proper and properly decided by the surrogates court because they had an affidavit that said he was the only heir. And that's the case of Galob versus Mielnicki. Have a good day. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.